And welcome back to Dads on the Air, coming to you around Australia on the Community Radio Network. In this program, we bring you informing and entertaining conversations with a wide range of interesting people on topics of fatherhood, men's and boys' issues. Hi, I'm Bill Cable, and with me in the studio today is Ken Thompson. And our special guest today is Edward Kruk. Edward is the Associate Professor of Social Work at the University of British Columbia, specialising in child and family policy, and author of numerous publications, including his latest book, The Equal Parent Presumption, Social Justice in the Legal Determination of Parenting After Divorce. So, Ed, welcome to the program.
Thank you. It's great to be on air with you.
So, Ed, you say that this is not a book from a father's rights group. What did provide the impetus for writing the book?
You know, I've had a long career of working with children and families, and my work has always proceeded from a child-focused perspective. So it's really the best interests of children that guide me in my work. And I've come to see over the years that the best interests of children are inextricably linked with the needs and interests of their parents as well. So, but sometimes they are distinct. Yeah, I think many fathers groups, of course, have advanced the idea of shared or equal parenting as in their interests, but more importantly, I see it as a child rights, or even more a responsibility that we have to children to ensure that their relationships with both their parents are protected, and that they get the best possible outcome in, you know, difficult situations like family transition attendant to divorce. So, yeah, I'm really proceeding from the perspective of children.
And that's something of a revolutionary approach, because people mouth the expression, in the best interests of the child. But in your book, you actually look at it from the child's perspective instead of a judge deciding what is in the best interests of the child. And I think that's the interesting part for me.
Yeah, it's quite interesting, because researchers told us that most of what we consider to be, quote, in the best interest of the child is really based on adult perspectives, often expert perspectives on what's best for children. But strangely, children haven't been consulted as to what their best interests are until very recently. And now we have research that has looked at this idea of the best interests of children, what are children's primary needs in times like divorce. And we've looked at the perspective of experts like judges and mediators, lawyers, psychologists, and mental health professionals on the one hand. We've looked at it from the perspective of parents, and also now, more recently, there is research that has been begun to ask children themselves what they consider to be their best interests. And these viewpoints markedly diverge, not so much parents and children, but judges, for example. When they talk about the best interests of children, they seem to be most preoccupied with determining which parent has the most deficits, or which parent is the most suited to be the parent. Really, you know, judges aren't trained in child development and family dynamics, so really they have very little expertise in this area. But when you ask children themselves, they have very differing views. Now, there was a groundbreaking landmark study from Arizona a few years ago that asked about 800 to 900 young adult children of divorce who had lived through their parents' divorce as children what they considered to be most important to their well-being. And they very clearly identified the importance of maintaining meaningful relationships with each of their parents as in their best interest. They equated the children's best interests with shared parenting, essentially, where they had as much time as possible with each of their parents, and as equal a proportion of time as possible with each of their parents, so they could get the best from both parents. I use the term the best interest of the child from the perspective of the child. I think we need to go beyond judicial biases and stereotypes and what perhaps parents who are at high conflict with each other over what's best for children. We need to go beyond those perspectives and really look at what the research is that's focused on children's views on their best interests and their fundamental needs has told us.
Yes, what I particularly like in your book is the way you're prepared to challenge assumptions and even some expressions, like you say a judge is not really awarding custody, they are really sanctioning a removal from one of the parents. And when you look at it from the child's perspective, that's really what's happening, isn't it?
Yes, the child is essentially losing the day-to-day care of one parent when judges apply a primary caregiver presumption or a bias that children are better off in high-conflict situations in the primary care of only one parent. And that's absolutely true. We talk about awarding custody, but nothing could be further from the truth. Essentially, judges are removing a parent from the life of a child, and that's particularly devastating. We often talk about this idea of awarding custody, or that parents are the ones who, perhaps fathers lose out, but in fact it's the child who suffers the most from that loss. So I think, we have to be honest about that and realize this is contrary to children's rights. The non-discrimination clause, for example, Article 2 of the UN Convention on the Rights of the Child, which states very clearly that we should not be discriminating against different groups of children on the basis, for example, of parental status. We apply this indeterminate best interest standard, which is really a discretionary-based standard. It's really up to the judge to determine what the best interest of the child. They apply their own idiosyncratic biases and end up, in most cases, removing a parent from the day-to-day routine caregiving responsibility. That's another point I'd make, is that we talk too much about rights, whether that's parents' rights or children's rights. We don't talk enough about responsibilities, and the responsibilities that we collectively have, both parents and representatives of social institutions like judges, to ensure that children's needs are addressed. Children's needs and their fundamental needs seem to get lost in the whole discourse around mother's rights versus father's rights. This whole rights-based discourse, the more we talk about rights, the less we seem to be concerned about responsibilities. And it is the responsibility of social institutions, such as the courts, to support parents in the fulfillment of their parenting responsibilities to their children's needs. We don't really hold these institutions or representatives of these institutions, whether it's social welfare or education or the medical system or the courts. We don't hold folks accountable for their decisions.
I think that's one of the biggest disappointments in this area, is that people that don't have any experience with family law come to the court expecting a fair determination, and you find judges making these discretionary decisions with no expertise in the area, which can affect people's lives.
I think it's a fundamental principle in law that the best laws are those that limit judicial discretion, especially in the family arena, where judges have no training in the finer points of child development and family dynamics, a very kind of delicate matter. They kind of impose their biases, essentially, which more often than not turn out to be assumptions that really have no foundation.
And we're speaking with Edward Kruk, Associate Professor of Social Work at the University of British Columbia. We're going to take a short break now and listen to a song about an anguished statement dealing with the pain of separation. This is a song called Stay by Lorraine Ellison.
Where did you go when things went wrong, baby? Who did you run to and find a shoulder to lay your head upon? Baby, wasn't I there? Didn't I take good care of you? No, I can't believe you're leaving me.
Stay by Lorraine Ellison, and we're speaking today with Edward Kruk, Associate Professor of Social Work at the University of British Columbia, about his most recent book, The Equal Parent Presumption, Social Justice in the Legal Determination of Parenting After Divorce. Ed, we were just talking about the effect of the judges and the courts. People will often raise the situation of what should happen when there's high parental conflict. What do your studies show about equal shared time when there is this high parental conflict?
Well, there's probably been more research done on this question than any other in the past 5 years particularly. Now, some years ago it was found that children moving back and forth between parents in situations of high conflict was problematic for children. But it turned out that those studies were not measuring so much the amount of time that children spent in each parent's household. They were more focused on the number of alternations. So if children are moving back and forth frequently and exposed to parental conflict during these transitions, then that's going to have a negative impact. But more recently, we've actually looked at the impact of differing custodial or residential arrangements on children, and the results are extremely encouraging as far as shared parenting is concerned. First of all, in situations of high conflict, I'm not talking about situations of family violence, but rather conflict, where perhaps children have been exposed to conflict for an extended period of time with the marital discord in the family and then during the separation. We found that over time, with shared parenting, conflict decreases because neither parent is threatened with the loss of their child. They have really kind of considering shared parenting as an arrangement in which neither of them is going to lose contact with their children or become alienated from their children. As the dust settles over time, conflict is reduced in shared parenting situations. However, where one parent is the primary caregiver, especially in situations where the care was shared in the two-parent family, that's a recipe for disaster. The conflict escalates as one parent tries to get more time with the child while the other is trying to limit the child's contact with the non-residential parent. These conflicts and litigation around access time can go on for years, and so in those cases, conflict markedly increases over time. So we have a really solid body of research now that tells us that shared parenting is associated with decreases in conflict levels. The other interesting point is that fully 50% of first-time family violence situations occur during and after divorce, parental separation, in the context of adversarial, winner-take-all battles over who will get the primary responsibility or primary residence of children. Where there was no violence in the past, a large proportion of first-time violence occurs within that context of an adversarial battle, both parents wanting the children to be with them as much as possible and really feeling threatened, each of them feeling threatened that they may lose that court battle and be denied kind of a routine involvement in their children's lives. So there's quite a bit from all over the world, really, and I think the conclusion now is that high conflict should never be a reason for limiting a child's contact with either of the parents. We also know that in high conflict situations, what is really most dangerous for children is the fact that they are liable to lose contact with one parent, and that's more devastating than just simply the exposure to conflict. Shared parenting provides a buffer or kind of reduces the impact of high conflict for children. It's clearly what's most important to children from their own perspective, but also looking at adults, both parents' adjustment to the consequences of divorce. We see conflict going down with shared parenting and going up with the kind of traditional primary residence model.
And you would draw the distinction between conflict between the parents themselves and then violence, say, towards the child. And it doesn't necessarily follow that if the parents are in conflict with each other, that one parent's going to be violent towards the child.
Exactly. In fact, family violence is a reality, and I think in cases of where it's established and substantiated that violence has occurred, spousal interparental violence, that is a form of child abuse that has devastating consequences for children. And in those cases, most researchers, practitioners would call for a rebuttable presumption against shared parenting in substantiated cases of violence. After all, it is a form of child abuse, just exposure to parental conflict, or violence between parents, rather, not so much conflict. It's very important to distinguish among different levels of conflict and violence. At the extreme end is family violence, and in many of those cases, of course, with safety measures in place and supports in place for both parents and children, over time, shared parenting might be the best outcome, but you have to proceed very carefully, as you would with a two-parent family where there's family violence. We don't want children exposed to that. Really, these are a relatively small percentage of cases of divorce. The vast majority involve some degree of parental conflict, but not violence. And as I say, over time, conflict is reduced. Whereas with shared parenting, whereas with the other situation of primary residence with one parent and the other one effectively cast in the role of visitor, an avuncular relationship where their previous relationship with their children, the post-divorce relationship bears no resemblance to the previous relationship. We know that those cases, violence, or rather conflict escalates sometimes to the point of violence, and we want to prevent those situations from occurring.
Well, interestingly, with the favoritism given to sole custody awards, I think your study would show that sole custody is correlated with parental alienation and violence, as we've just been talking about. We're going down the wrong path in pursuing this sole custody award.
Absolutely, yes. We've seen in the research and the practitioner community, particularly among mental health practitioners, a paradigm shift occurring away from the notion that children are best served in kind of one stable relationship with one parent to recognizing that shared parenting and both parents actively involved in children's lives is absolutely fundamental for children's adjustment to divorce at all ages and stages of development of children. But now we're also seeing jurisdictions around the world embracing shared parenting as the foundation for family law, and that's something to be really optimistic about. For many years now, we've seen sort of a gender convergence, I would call it, in child care roles and responsibilities in two-parent families. And we really encourage that idea that both parents are now working outside the home in most families, and that really both parents have to share the responsibility for child rearing, and they are doing that in two-parent families, in many cases fairly equally. So we really encourage that notion or promote the idea of shared parenting in two-parent families. But after separation and divorce, we seem to kind of lose our focus a little bit, and there's less of an emphasis on the importance of shared parenting. So that's something to be addressed as well. But it is being addressed. The Council of Europe recently passed a resolution that urged member states to adopt shared parenting as the foundation of family law, and we're seeing any number of European jurisdictions moving in that direction, and many states in the U.S. as well. But some countries are still lagging behind.
And some people might say that equal shared parenting breaks down over time. Is that your study? Like they say, after a while the child will naturally go back to the mother.
absolutely no evidence of that I've been able to find. I've definitely heard that argument. But clearly, as children get older, they want more of a say in their routines and their relationships, and of course, they focus for teenagers is achieving independence from both parents, and they like to have more of a say in their living arrangements. However, based on the research that's looked at children's perspectives directly, they want some form of shared parenting all the way through, right from very young children to older children. So although the actual residential arrangements, the specifics of those residential arrangements will change over time, and of course even in high conflict situations where perhaps parents start off in more of a parallel parenting mode, over time as the dust settles and conflict diminishes, then parents themselves become a little bit more cooperative and flexible in terms of making accommodations and respecting each other's parenting, and so the shared parenting arrangement that people start off with right after divorce does change over time. There's no question about that. But it's not a matter of suddenly kids wanting to be in the exclusive care of one parent only. That happens in some cases, but really most important for children, according to the studies that have asked children themselves, is that they want as equal as possible a relationship with both parents. They really value both parents in most cases equally and want to maintain those primary attachments with both parents.
Your suggested way of dealing with this area is to have two presumptions, and which would seem to satisfy the critics as well. One presumption would be, of course, equal shared parenting time, and the other presumption would be that if there is violence proven in another court, a criminal court, custody would go to the non-offending parent. And that seems an eminently sensible way.
At least for a period of time. Yes. I think the primary concern in the second scenario you described is the safety of the child, and we need to establish, above all, establish that as safety for children before we can really examine, whatever arrangement, keeps children shielded from violence. That's really the key. But that's not to say that it'll remain like that forever. I think if parents are able to get support and help and work through that kind of pattern of violence, then just as in two-parent families where we see abusive parents, they're gradually reintegrated into the child's life, and parents are taught sort of nonviolent conflict resolution and more effective parenting methods. So my position is that we should apply the same standard to children of divorce as we do to children in two-parent families. And clearly where children are exposed to violence in a two-parent family or to child abuse, then we intervene and act to ensure that the child is safe and not exposed to violence or abuse. And the same should pertain to the post-divorce situation. So that means that an allegation of abuse is not enough. It really has to be substantiated because mutual allegations are fairly common within the adversarial system. Where they are investigated, some of these allegations, they're found not to be substantiated in many cases. So only after a fairly thorough and immediate child welfare assessment do we make those decisions.